I was sitting on the porch of my inherited cabin in the Adirondack Mountains of upstate New York, watching the sunset paint the sky orange and purple, when a woman in a cream-colored pantsuit marched up my gravel driveway with a clipboard and an expression that could curdle milk. I had owned this property for exactly 63 days, and I already knew this visit was going to be trouble. "Excuse me," she called out, her voice sharp enough to cut glass. "I'm Brenda Morrison, president of the Pine Ridge Community Association, and I need to speak with you about your illegal occupation of this property." I set down my coffee mug and stood up, keeping my expression neutral. "I'm Keith Walker. I own this cabin. My uncle left it to me when he passed away in March." Brenda stopped at the bottom of the porch steps, her perfectly manicured nails tapping against the clipboard. She was probably in her mid-50s, with highlighted blonde hair styled in that aggressive bob cut that seemed to be standard issue for HOA presidents. "That's interesting, Mr. Walker, because according to our records, this property has been abandoned for over 7 years. I've been maintaining it, paying for landscaping services, and keeping vagrants away. I filed an adverse possession claim with the county last week." I felt my jaw tighten. As a property attorney in Manhattan, I dealt with real estate disputes daily, but I never expected to encounter one at my own vacation cabin. Adverse possession requires continuous occupation for 10 years in New York State, Ms. Morrison. Even if your claims were true, which they're not, you wouldn't qualify. Her eyes narrowed. "I've done my research, Mr. Walker. Your uncle stopped coming here in 2018. Nobody has lived here since. That's 7 years of abandonment, and I have documentation of every dollar I've spent maintaining this eyesore." "My uncle had cancer," I said, keeping my voice level despite the anger building in my chest. "He couldn't travel, but he paid his property taxes every year, hired a local caretaker to check on the place monthly, and never abandoned it. Just because he wasn't here physically doesn't mean the property was abandoned." Brenda climbed 2 steps, invading my personal space. "The HOA has standards, Mr. Walker. This cabin violates at least 14 of our community guidelines. The paint is peeling, there's no approved landscaping plan on file, and you haven't submitted an occupancy request form. Furthermore, since I filed the adverse possession claim first, the burden of proof is now on you to demonstrate uninterrupted ownership." I took a deep breath. "This property isn't part of your HOA. My uncle bought this land in 1987, decades before Pine Ridge Community Association even existed. He never signed any covenant agreements. The HOA was established in 2012, and all properties within the Pine Ridge geographical boundaries are automatically included," Brenda insisted. "You received the welcome packet, didn't you?" "I received a manila envelope full of threats and fee schedules," I replied. "But that doesn't create a legal obligation. HOAs require voluntary membership through signed covenants that run with the land. Show me my uncle's signature agreeing to join your association." Brenda's face flushed red. This is exactly the kind of entitled attitude that ruins communities. I've put hundreds of hours into keeping this neighborhood pristine, and property owners like you think you can just ignore the rules everyone else follows. "Rules that I never agreed to," I pointed out. "Ms. Morrison, I understand you're passionate about the community, but you can't force someone into an HOA membership retroactively, and you definitely can't claim adverse possession of property that's been continuously owned and maintained." She descended the steps and stabbed a finger toward me. "We'll see what the county clerk says about that. I've already filed the paperwork, paid the filing fees, and consulted with our attorney. You have 30 days to vacate this property or prove your ownership in court." "Your attorney gave you terrible advice," I said, "but I'll be happy to see you in court." Brenda spun on her heel and marched back down the driveway, her clipboard clutched to her chest like a shield. I watched her climb into a white Lexus SUV with a Pine Ridge Community Pride bumper sticker and speed away, gravel crunching under her tires. I pulled out my phone and called my colleague Marcus Chen, who specialized in property disputes in upstate New York. He answered on the second ring. "Keith, how's the vacation cabin?" Marcus asked cheerfully. "About to become a legal battleground," I replied. "I need you to pull every document related to adverse possession claims filed in Essex County in the last 2 weeks. Also, get me the incorporation papers for something called Pine Ridge Community Association." HOA trouble? Marcus guessed. The worst kind. Their president thinks 60 days of me not living here full-time equals abandonment, and she's filed an adverse possession claim. Marcus whistled. That's not how any of this works. Send me the details and I'll have a full brief ready by Monday. I spent the rest of the evening documenting everything. I photographed the cabin from every angle, showing that while it needed some cosmetic updates, it was structurally sound and well-maintained. I pulled up my uncle's bank records, which his estate attorney had provided during probate, showing regular payments to Robert Henderson, a local handyman who checked on the property monthly for the past 7 years. I gathered property tax receipts, utility bills, and insurance payments, creating an ironclad paper trail of continuous ownership. The next morning, I drove into Lake Placid, the nearest town, to visit the Essex County Clerk's office. The building was a charming brick structure on Main Street, and the clerk, a woman in her 60s named Patricia, greeted me warmly. I need to see an adverse possession claim filed recently, I said. The property is 2847 Forest Ridge Road. Patricia typed into her computer, her expression growing concerned. Oh, yes. Mrs. Morrison filed this last Thursday. She's filed 3 other adverse possession claims in the past 2 years, actually. 3? I leaned against the counter. That's unusual. Very, Patricia agreed quietly, glancing around to make sure we were alone. Between you and me, she's trying to expand the HOA's control over properties that predate the association. The other claims were withdrawn when the property owners hired attorneys, but she keeps trying. Can you print everything you have on those previous claims and her current one against my property? Patricia hesitated. It's all public record, so yes. But Mr. Walker, be careful. Mrs. Morrison has a lot of influence around here. Her husband is a retired state senator, and she's used to getting her way. I appreciate the warning, I said, but I'm a property attorney and I don't respond well to bullying. Patricia printed out a thick stack of documents. I paid the nominal fee and spent the next hour at a coffee shop across the street, reviewing everything. The pattern was clear and disturbing. Brenda had targeted 4 properties total, all of which bordered the HOA's territory. 2 were vacation cabins like mine, owned by people who lived out of state. 1 was a small farm whose elderly owner had moved to a nursing home. The 4th was my property. In each case, Brenda claimed she had maintained the property for years and deserved ownership through adverse possession. In each case, she was wrong about the legal requirements, but she was counting on the property owners being too intimidated or too ignorant to fight back. I called Marcus again. It's worse than I thought. She's running a scam, trying to gobble up properties through fraudulent adverse possession claims. Can you prove it's fraud? Marcus asked. I'm going to try. I need you to reach out to the 3 other property owners she targeted. I want to know if she pressured them, what she said, and whether she knew her claims were baseless. On it. Keith, if you can prove she's filing frivolous legal claims to intimidate people, you might have grounds for a lawsuit yourself. That's exactly what I'm thinking. I spent the rest of the weekend fortifying my position. I visited Robert Henderson, the handyman my uncle had hired. He was a weathered man in his 70s who had lived in the area his entire life. Your uncle was a good man, Robert told me, sitting on his own porch with a glass of iced tea. He called me every month like clockwork, even when he got sick. Wanted to make sure the cabin was secure, the pipes weren't freezing in winter, and the roof wasn't leaking. I've got 7 years of invoices to prove it. I need copies of everything, I said, and I need you to be willing to testify that the property was never abandoned. Robert nodded firmly. I'll do it. Brenda Morrison has been a thorn in this community's side since she moved here. She thinks because her husband had some political power, she can push everyone around. Most folks are too polite to stand up to her. I'm not most folks, I replied. On Monday morning, Marcus emailed me his research. The Pine Ridge Community Association had been incorporated in 2012 with 23 founding members who all signed covenant agreements. The covenants included detailed architectural guidelines, maintenance standards, and fee structures. However, there was no mechanism in the bylaws for automatically including properties that existed before the HOA's formation. More importantly, Marcus had tracked down the 3 other property owners Brenda had targeted. 2 agreed to conference calls with me, and their stories were remarkably similar. Brenda had approached them, claimed their properties were abandoned, and filed adverse possession claims. When they hired attorneys and demonstrated continuous ownership, she withdrew her claims but made their lives miserable with HOA violation notices and harassment. "She sent me 17 violation notices in 1 month," said Gerald Fitzpatrick, who owned a vacation cabin 3 miles from mine. "Everything from my grass being the wrong shade of green to my mailbox being 2 inches too far from the road. None of it was real, but I got tired of fighting and eventually sold the place just to get away from her." "That's a pattern of harassment," I noted. "Did you ever consider suing her?" "I just wanted to be done with it," Gerald admitted. "But if you're going after her, I'll provide whatever documentation you need." The second property owner, Linda Yoshida, had a similar story. "She's dangerous because she's just smart enough to know how to abuse the legal system, but not smart enough to realize when she's crossed the line into fraud. I spent $10,000 in legal fees defending my property, and she withdrew her claim the day before the hearing. By Wednesday, I had built a comprehensive case file. I had proof of continuous ownership, documentation of Brenda's pattern of fraudulent claims, and testimony from multiple victims. I drafted a formal response to her adverse possession claim and a counterclaim for harassment, abuse of process, and filing false legal documents. But before I filed anything, I decided to give Brenda one chance to back down gracefully. I drove to the address listed for the Pine Ridge Community Association's office, which turned out to be Brenda's house, a massive colonial with a manicured lawn that looked like it belonged in a magazine. She answered the door in yoga clothes, holding a green smoothie. "Mr. Walker, I hope you're here to discuss your move-out timeline." "I'm here to offer you an opportunity to withdraw your fraudulent claim before this gets ugly," I said calmly. "I have documentation proving continuous ownership of my property, testimony from my uncle's caretaker, and evidence of your pattern of filing baseless adverse possession claims against other property owners." Brenda's expression didn't change. "I don't know what you're talking about." "Gerald Fitzpatrick, Linda Yoshida, and Thomas Brennan," I listed. 3 property owners you targeted with the same scam. You file adverse possession claims, hoping they'll be intimidated into selling or abandoning their property. When they fight back, you withdraw and move to the next target. "Those were legitimate claims based on thorough research," Brenda insisted. "If those property owners chose to settle rather than go through litigation, that's their business decision." "You withdrew all 3 claims," I pointed out, "because you knew you couldn't win. You're not stupid, Ms. Morrison. You know the legal requirements for adverse possession, and you know you don't meet them. What you're doing is fraud." She stepped closer, her voice dropping to a dangerous whisper. "My husband spent 20 years in the state Senate. I have connections throughout this county, Mr. Walker. If you think you can come into my community and challenge me, you're going to find out exactly how expensive legal battles can become." "I'm a property attorney in Manhattan," I replied. "I handle cases worth millions of dollars. Your little HOA intimidation tactics don't scare me. Withdraw your claim by Friday, or I'll file a counterclaim that will drag you and your association through a very public legal fight." Brenda's face turned red. "Get off my property." "Gladly. You have until Friday." I drove away, my heart pounding. I had dealt with difficult opposing counsel before, but something about Brenda's absolute conviction that she was untouchable made this personal. She genuinely believed her social status and connections made her immune to consequences. Friday came and went with no response from Brenda. On Monday morning, I drove to the county courthouse and filed my response to her adverse possession claim, along with a counterclaim seeking damages for harassment, abuse of process, slander of title, and intentional infliction of emotional distress. I requested a hearing date and asked for expedited consideration given the frivolous nature of the original claim. The clerk who processed my filing looked impressed. "This is quite a comprehensive response." "I'm thorough," I said simply. 2 days later, I received a certified letter from an attorney named Donald Pritchard, representing the Pine Ridge Community Association. The letter was full of bluster about my violation of community standards and threats of additional legal action if I didn't comply with HOA guidelines. I called Donald's office and got him on the phone within minutes. "Mr. Pritchard, I'm Keith Walker. I received your threatening letter and I wanted to clarify something before you waste any more of your client's money. Mr. Walker, my client has made reasonable requests. Your client has no authority over my property, I interrupted. My uncle never signed covenant agreements with the HOA, which means I'm not a member. You can't enforce rules I never agreed to follow. Furthermore, your client filed a fraudulent adverse possession claim against my property, and I filed a counterclaim seeking significant damages. There was a pause. I was under the impression that all properties in the geographical area were subject to HOA oversight. Then your client misrepresented the facts, I said. I suggest you review the actual covenant agreements and determine whether you want to continue representing someone engaged in a pattern of legal harassment. I have documentation of at least 3 other property owners she's targeted with similar fraudulent claims. I'll need to review the matter further, Donald said carefully. You do that. In the meantime, tell Mrs. Morrison that every threatening letter, every bogus violation notice, and every attempt to interfere with my property rights gets added to my damages claim. I hung up, feeling a grim satisfaction. Donald Pritchard sounded like a competent attorney who had been fed false information by his client. Once he realized what Brenda was actually doing, he would likely withdraw from representation. That prediction proved accurate faster than I expected. 3 days later, I received a notice that Donald Pritchard had filed a motion to withdraw as counsel for the Pine Ridge Community Association, citing irreconcilable differences with the client regarding legal strategy. Brenda was now representing herself, which was a terrible idea in any legal proceeding, but especially in one where she was clearly in the wrong. The hearing was scheduled for late June in the Essex County Supreme Court. I drove down from the cabin on a Thursday morning, wearing my best Navy suit and carrying a briefcase full of documentation. The courtroom was small but dignified, with wood paneling and a New York State flag in the corner. Brenda arrived wearing a pink blazer and carrying 3 large binders. She was alone, having refused to hire another attorney after Donald Pritchard withdrew. Judge Helen Cartwright presided, a woman in her early 60s with silver hair and a no-nonsense demeanor. She reviewed the case file with a deepening frown. Mrs. Morrison, you filed an adverse possession claim against property at 2847 Forest Ridge Road, claiming you maintained it for 7 years while it was abandoned. Is that correct? Yes, Your Honor, Brenda said confidently. I've maintained that property at considerable personal expense, and the previous owner had abandoned it for years. Mr. Walker, you're the current owner and you dispute this claim? I do, Your Honor. I inherited the property from my uncle, Richard Walker, who died in March. He owned the property continuously from 1987 until his death, paid all property taxes, maintained insurance, and hired a local caretaker to check on it monthly. I have documentation of all of this. Judge Cartwright gestured for me to proceed. I laid out my case methodically, presenting tax receipts, utility bills, insurance policies, and Robert Henderson's invoices. Robert himself was present and testified clearly about his monthly visits to the property. And you were compensated for these visits? The judge asked. Yes, madam, Robert confirmed. Mr. Richard Walker paid me $50 a month to check on the cabin, make minor repairs, and report any problems. I did that for 7 years until he passed away. Judge Cartwright turned to Brenda. Mrs. Morrison, the definition of abandonment requires the owner to relinquish all claims and control over the property. Clearly, Mr. Richard Walker maintained continuous control. What evidence do you have to the contrary? Brenda opened one of her binders. Your Honor, I have photographs showing peeling paint, overgrown grass, and general neglect. The property was an eyesore that violated community standards. Was the property part of your HOA? Judge Cartwright asked. All properties in the Pine Ridge area are subject to HOA oversight, Brenda insisted. That's not an answer to my question. Did Mr. Richard Walker sign covenant agreements making his property subject to HOA governance? Brenda hesitated. The property is geographically within our boundaries. That's also not an answer. Judge Cartwright looked at me. Mr. Walker, my uncle never signed any HOA agreements, Your Honor. His property predates the association's formation by 25 years, and there's no mechanism in the HOA bylaws for automatically including existing properties. The judge made a note. Mrs. Morrison, even if the property had been poorly maintained, which the evidence suggests it was not, cosmetic issues don't constitute abandonment. Furthermore, adverse possession in New York requires 10 years of exclusive, continuous, open, and notorious possession that is hostile to the owner's rights. You filed your claim after 60 days of Mr. Walker taking ownership. Can you explain your legal theory here? Brenda's confidence wavered. I maintained the property for 7 years before Mr. Walker arrived. That should count toward the 10-year requirement. Did you have the owner's permission to be on the property? Judge Cartwright asked. No, but then you were trespassing, not establishing adverse possession. Mrs. Morrison, I'm going to be frank with you. This claim is frivolous. Adverse possession is a legitimate legal doctrine with strict requirements, and you meet none of them. More concerning is Mr. Walker's counterclaim, which alleges this is part of a pattern of harassment. That's completely false, Brenda protested. I stood. Your Honor, I have documentation of 3 other property owners Mrs. Morrison targeted with similar fraudulent adverse possession claims. All 3 claims were withdrawn when the owners mounted legal defenses, but only after those owners incurred significant legal expenses. Judge Cartwright looked genuinely angry now. Mrs. Morrison, did you file adverse possession claims against properties at 1843 Lakeview Drive, 4012 Mountain Pass Road, and 756 Spruce Hollow Lane? Those were legitimate, yes or no? Yes, but the circumstances were different. Were all 3 claims withdrawn before hearings? Brenda's face was bright red. The property owners and I reached understandings. They hired lawyers and you backed down because you knew you'd lose, Judge Cartwright said coldly. Mrs. Morrison, I'm dismissing your adverse possession claim with prejudice. Furthermore, I'm sanctioning you personally for filing a frivolous legal action. You will pay Mr. Walker's legal fees and court costs. As for the counterclaim, that will require a separate hearing, but I'm inclined to take it very seriously given this pattern of behavior. Your Honor, I was acting in good faith to protect my community. You were abusing the legal system to intimidate people into abandoning their property rights, the judge interrupted. If Mr. Walker's allegations are proven, you may face additional consequences. This hearing is concluded. I gathered my documents, feeling vindicated. Brenda remained seated, staring at her binders in shock. As I left the courtroom, Robert Henderson clapped me on the shoulder. That was something to see, he said with a grin. Nobody's ever stood up to her like that. It's not over yet, I replied. The counterclaim hearing is in 3 weeks. Over the next few weeks, I continued building my case. Marcus helped me draft detailed damages calculations, including my time spent defending against Brenda's claim, Robert's testimony fees, filing costs, and the value of the stress and harassment. I also reached out to the 3 previous victims and convinced 2 of them, Gerald Fitzpatrick and Linda Yoshida, to testify about their experiences. The Pine Ridge Community Association held an emergency meeting, according to local gossip I heard at the Lake Placid coffee shop. Several members were furious that Brenda's personal vendetta had exposed the HOA to legal liability. There was talk of removing her as president, but Brenda had structured the bylaws to make that nearly impossible without a supermajority vote. Meanwhile, Brenda doubled down. She began driving past my cabin several times a day, taking photographs and documenting what she claimed were violations. She sent me 17 violation notices in 1 week, citing everything from my grass height to my cabin's unapproved color scheme to my failure to install appropriate outdoor lighting. Each notice went into my evidence file, demonstrating ongoing harassment. The counterclaim hearing arrived in late July. This time, the courtroom was more crowded. Several Pine Ridge HOA members attended, and I recognized a reporter from the local newspaper in the back row. Judge Cartwright looked even less pleased than during the first hearing. Mrs. Morrison, I'm looking at dozens of violation notices you sent Mr. Walker in the 6 weeks since our last hearing. Can you explain why you continued to assert authority over a property this court has ruled is not subject to your HOA's governance? Your Honor only ruled on the adverse possession claim, Brenda argued. The HOA's authority is a separate matter. Mr. Walker, has Mrs. Morrison continued harassing you? I presented the stack of violation notices. These are all dated after the previous hearing, Your Honor. Each one claims I've violated HOA rules that don't apply to my property. She's also been driving past my cabin multiple times daily, taking photographs and intimidating me. Judge Cartwright examined the notices, her expression growing darker. Mrs. Morrison, you sent a violation notice claiming Mr. Walker's mailbox was the wrong shade of red? HOA guidelines specify approved colors for HOA members, which Mr. Walker is not. You sent another notice claiming his grass was 3/4 of an inch too tall? Maintenance standards are crucial for property values. You don't have authority over his property. Judge Cartwright's voice rose. This is exactly the kind of harassment Mr. Walker alleged. You've used your position to make his life miserable because he dared to challenge you. Gerald Fitzpatrick took the stand and described his ordeal with Brenda. After I hired an attorney and proved I owned my cabin outright, she made my life hell. Violation notices almost daily, threatening to fine me thousands of dollars, sending HOA members to photograph my property. I eventually sold the cabin at a loss just to escape her. Linda Yoshida testified next, telling a nearly identical story. She cost me $10,000 in legal fees, and when I won, she started a campaign of harassment. My mailbox was vandalized twice. Someone filed a false report with code enforcement, claiming my septic system was failing. I had to pay for an inspection to prove it was fine. She made ownership a nightmare. Judge Cartwright looked at Brenda. Do you have anything to say? These property owners didn't maintain their properties to community standards, Brenda said stubbornly. If they felt harassed, perhaps they should have simply followed the rules. Rules they never agreed to follow, the judge said. Mrs. Morrison, I'm finding in favor of Mr. Walker on all counts. You engaged in harassment, abuse of process, and intentional infliction of emotional distress. I'm awarding him $30,000 in damages, which includes his legal fees, lost time, and compensation for the stress you've caused. Additionally, I'm ordering you to cease all contact with Mr. Walker and to stop sending him any HOA-related communications. If you violate this order, you will face contempt charges. Brenda stood abruptly. This is outrageous. I've dedicated years to improving this community, and this court is punishing me for caring about property values and standards. You're being punished for breaking the law, Judge Cartwright said firmly. You don't get to harass people just because you disagree with how they maintain their property. This court is adjourned. I left the courthouse feeling a profound sense of relief. $30,000 wouldn't change my life, but the principle mattered. Brenda Morrison had spent years bullying people, secure in her belief that her social status made her untouchable. She had finally faced consequences. The local newspaper ran a front-page story about the case. The headline read, HOA President Sanctioned for Fraudulent Property Claims. The article detailed Brenda's pattern of targeting property owners and the court's decisive ruling against her. Within days, it was picked up by regional news outlets and even some national property law blogs. The Pine Ridge Community Association held another emergency meeting. This time, enough members had seen enough. They voted to remove Brenda as president, narrowly achieving the supermajority required by the bylaws. The new president, a retired schoolteacher named Margaret Torres, immediately reached out to me. Mr. Walker, I want to apologize on behalf of the association, Margaret said when she called. What Brenda did was unconscionable. We had no idea she was filing these fraudulent claims or harassing non-members. I appreciate that, I replied. For what it's worth, I have no problem with the HOA itself. I just don't want to be forced into membership or subjected to rules I never agreed to follow. Completely understandable. We're revising our bylaws to make it crystal clear that only properties with signed covenants are subject to HOA governance. We're also implementing oversight procedures to prevent any future president from abusing their authority. That conversation gave me hope that the community might actually improve under new leadership. But Brenda wasn't done. 3 weeks after the counterclaim hearing, I received notice that she was appealing Judge Cartwright's decision. The appeal was rambling and incoherent, filled with accusations that I had conspired with the judge and other property owners to destroy her reputation. I called Marcus. She's appealing. Let her, Marcus said. The record is clear, and appellate courts don't like frivolous appeals. This is just going to cost her more money." He was right. The appellate court denied her appeal within 6 weeks, calling it wholly without merit and imposing additional sanctions for wasting judicial resources. I thought that would be the end of it. I was wrong. In early September, I was at the cabin for a long weekend when I noticed fresh tire tracks in my driveway. Someone had been on my property while I was back in Manhattan. Nothing was damaged, but it felt like a violation. I installed security cameras the next day, covering all approaches to the cabin. 2 nights later, the cameras caught Brenda walking around my property at midnight, taking photographs with a flashlight. She measured my grass height, examined my paint, and tried my door handles. I called the Essex County Sheriff's Office. A deputy named Ryan Kellerman arrived within 30 minutes. "That's clear trespassing," Deputy Kellerman said after reviewing the footage. "And given the court order prohibiting her from contacting you, this is also contempt of court." "I want to press charges," I said. "I'll need a copy of that footage and the court order. We'll bring her in for questioning." Brenda was arrested the following afternoon. The charges included criminal trespassing and contempt of court. She spent a night in jail before posting bail, and her mugshot appeared in the local newspaper. The community reaction was swift and brutal. Brenda's friends distanced themselves, HOA members expressed outrage, and even her husband, the retired state senator, released a statement saying he was deeply disappointed in her actions. The criminal case proceeded quickly. Brenda hired a criminal defense attorney who tried to argue that she was simply checking on properties in her capacity as a former HOA president. But the video footage was damning. She had clearly targeted my property specifically, and the court order was unambiguous. In October, Brenda pleaded no contest to criminal trespassing and contempt of court. She was sentenced to 6 months of probation, ordered to pay additional fines, and required to attend anger management counseling. The judge also extended the no-contact order for 5 years. "Mrs. Morrison, you had every opportunity to walk away from this situation," the judge told her during sentencing. "Instead, you escalated repeatedly, breaking the law and violating court orders. You're fortunate you're not facing jail time. If you violate probation or the no-contact order, that will change." Brenda left the courthouse looking diminished, her husband walking stiffly beside her. I almost felt sorry for her, but then I remembered Gerald Fitzpatrick selling his cabin at a loss and Linda Yoshida's $10,000 in legal fees. The Pine Ridge Community Association issued a formal apology to me and the other affected property owners. Margaret Torres proved to be an excellent president, focusing on actual community improvement rather than aggressive enforcement of petty rules. The HOA offered to pay for professional landscaping at my cabin as a gesture of goodwill, which I accepted. Robert Henderson continued checking on the property when I was in Manhattan, though now we were friends rather than just business associates. He told me that Brenda had become a pariah in the community, avoided at the grocery store and the coffee shop. "People finally saw who she really was," Robert said. "She spent so many years pretending to care about the community, but it was always about control and power. You exposed that." I spent Thanksgiving at the cabin that year, inviting Robert and his wife for dinner. We sat on the porch afterward, watching the first snow of the season fall softly through the pine trees. "Your uncle would be proud," Robert said. "He loved this place, and he would have hated seeing Brenda try to steal it." "I wish he could have seen this," I admitted. "He was always so peaceful about everything. I don't think he would have fought back the way I did." "Maybe that's why he left it to you," Robert suggested. "He knew you'd protect it." As winter settled over the Adirondacks, I found myself spending more time at the cabin and less time in Manhattan. My law firm allowed me to work remotely several days a week, and the peace of the mountains was a welcome change from the city's chaos. In December, I received a certified letter from Brenda's attorney, offering to settle any remaining disputes for $50,000 if I would agree to drop all claims and sign a mutual non-disparagement agreement. I called the attorney, a woman named Susan Ramirez. "Your client already lost in court, paid $30,000 in damages, was convicted of criminal charges, and is on probation. What exactly is she trying to settle?" "Mrs. Morrison is concerned about her reputation," Susan explained carefully. "The news coverage has been very damaging." Her actions were damaging, I replied. She filed fraudulent legal claims, harassed multiple property owners, and trespassed on my land in violation of a court order. The damage to her reputation is self-inflicted. She's prepared to pay you $50,000 for your agreement to cease discussing the case publicly. I laughed. Tell Mrs. Morrison I'm not interested in helping her save face. She should have thought about consequences before she spent years terrorizing property owners. The answer is no. Susan sighed. I'll convey your response. That was the last contact I had with Brenda or her representatives. As months passed and then years, the story became local legend. I heard versions of it repeated at the Lake Placid coffee shop, each telling slightly different but always emphasizing the same moral. Don't underestimate property owners who know their rights. The cabin became my sanctuary. I renovated it extensively, restoring the original wood floors, updating the kitchen, and adding a guest room. I kept the exterior rustic and true to my uncle's vision, but I made it mine. Linda Yoshida reached out in the spring, thanking me for holding Brenda accountable. I never had the energy to fight her the way you did, she admitted, but watching you win gave me some closure. She cost me time, money, and peace of mind. At least now everyone knows what she really is. Gerald Fitzpatrick sent a similar message along with a bottle of expensive scotch. You did what I should have done, he wrote. Sometimes standing up to bullies is exhausting, but it's always worth it. The Pine Ridge Community Association thrived under Margaret Torres's leadership. Property values increased, community events brought neighbors together, and the aggressive enforcement tactics of the Brenda Morrison era faded into memory. Margaret occasionally stopped by my cabin to chat, always careful to respect that I wasn't an HOA member and had no interest in becoming one. We're planning a 4th of July barbecue at the community center, she mentioned one afternoon. You're welcome to come as a guest, no strings attached. I'll think about it, I said, and I actually meant it. The community itself wasn't the problem. Brenda had been the problem. I attended the barbecue and met dozens of neighbors who thanked me for standing up to Brenda. Several shared their own stories of her pettiness and cruelty during her presidency. She fined me $200 because my Christmas lights were up 3 days past the approved date, one man told me. It was insane. She reported me to code enforcement claiming my deck was unsafe, a woman added. Cost me $1,500 for inspections and an engineer's report, all to prove it was fine. She just didn't like the color I'd painted it. These stories reinforced that I had done the right thing. Brenda's reign of terror had affected dozens of people, and ending it had been necessary. In the 3rd year after the initial confrontation, I received an envelope with no return address. Inside was a handwritten letter from Brenda Morrison. Mr. Walker, I hope this letter finds you well. I've spent considerable time in reflection and therapy, examining my behavior and the harm I caused. I realize now that my obsession with community standards and property values masked deeper issues of control and insecurity. I caused you and others significant distress, and for that I am truly sorry. I don't expect forgiveness, but I wanted you to know that I recognize the damage I inflicted and take full responsibility. I hope you enjoy the cabin and that it brings you the peace your uncle intended. Sincerely, Brenda Morrison. I read the letter twice, trying to determine if it was sincere or another manipulation. The handwriting was shaky, suggesting genuine emotion. The tone was humble, lacking the self-righteous indignation that had characterized all her previous communications. I showed it to Robert during his next visit. Do you believe her? I asked. Robert considered carefully. I think she got a harsh enough wake-up call that she had to confront herself. Whether that transformation is permanent, who knows? But at least she's taking responsibility. I decided not to respond to the letter. Acknowledgement felt like reopening a door I had firmly closed. If Brenda had genuinely changed, that was between her and her conscience. My obligation was to myself and to the property my uncle had entrusted to me. The cabin became more than just a vacation property. It became a symbol of standing up for principles, of refusing to be intimidated, and of honoring the legacy someone I loved had left behind. Every weekend I spent there, watching the seasons change over the mountains, felt like a victory. I eventually started a pro bono practice helping property owners fight HOA overreach. Marcus and I took on cases throughout New York and neighboring states, representing people who were being bullied by associations that had exceeded their authority. Word spread, and we became known as the attorneys you called when your HOA turned tyrannical. One case involved an elderly veteran being fined thousands of dollars for flying an American flag that violated HOA size restrictions. We won, citing federal law protecting flag displays. Another involved a family threatened with foreclosure over unpaid fines for having the wrong shade of beige siding. We proved the HOA had never properly notified them of the color restrictions and got all fines dismissed. Each victory felt like another nail in the coffin of petty tyranny. HO. As served legitimate purposes when managed responsibly, but too often they became vehicles for power-hungry individuals to torment their neighbors. Holding them accountable was satisfying work. 5 years after that first confrontation with Brenda Morrison on my porch, I was sitting in exactly the same spot, coffee mug in hand, watching the sunset paint the sky. The cabin had become home in a way my Manhattan apartment never had. I was considering making the move permanent, working remotely full-time and embracing mountain life. A car pulled into the driveway, and I tensed briefly before recognizing Margaret Torres's sedan. She got out, waving cheerfully. "Keith, I hope I'm not intruding," she called. "Not at all. Coffee?" "Please." We sat together on the porch, and Margaret handed me an envelope. "The HOA board voted unanimously to make you an honorary member. No fees, no obligations, no rules you have to follow. Just our way of thanking you for everything you did for this community." I opened the envelope to find a certificate with unnecessarily fancy calligraphy declaring me an honorary member of the Pine Ridge Community Association. "I don't know what to say," I admitted. "You don't have to say anything. You stood up to someone who was poisoning this community from within. You protected not just your own rights, but the rights of everyone she targeted. We wanted to acknowledge that." "Thank you, Margaret. This actually means a lot," she smiled. "Your uncle would be proud. Robert told me Richard was one of the kindest, most principled men he ever knew. The fact that he left this place to you shows he recognized those same qualities in you." After Margaret left, I sat on the porch until the stars came out, thinking about the journey from that first angry confrontation to this moment of peace. The cabin had been meant as a simple inheritance, a vacation property to escape the city. Instead, it had become a battleground where I defended principles that mattered deeply. Property rights, due process, and the rule of law weren't abstract concepts. They were the foundations that prevented powerful people from trampling those with less power. Brenda Morrison had believed her status and connections made her untouchable. She had learned otherwise. The mountain air was crisp and clean, carrying the scent of pine and earth. Somewhere in the distance, an owl hooted. This place, this beautiful piece of the Adirondacks, was mine not just legally, but morally. I had fought for it, defended it, and honored my uncle's memory by refusing to let anyone steal it. The story could have ended differently. If I hadn't been a property attorney, if I hadn't had the resources to fight back, if I had been intimidated by Brenda's threats and connections, she might have won. That's what she had counted on with her previous victims. She had chosen the wrong target. I raised my coffee mug in a silent toast to my Uncle Richard, to Robert Henderson, to Gerald Fitzpatrick and Linda Yoshida, to Marcus Chen and Judge Cartwright, and to everyone else who had played a role in this saga. Justice wasn't always swift or easy, but when it came, it was worth the fight. The cabin lights glowed warmly behind me, and ahead the forest stretched dark and mysterious under the stars. This was home. This was victory. This was the life my uncle had wanted me to have, and I had defended it against someone who believed rules didn't apply to her. Brenda Morrison had filed adverse possession on my cabin after 60 days, not knowing I was a property attorney. That single miscalculation had unraveled her entire scheme and brought justice not just for me, but for every property owner she had victimized. The courts had spoken, the community had responded, and the law had worked exactly as it was supposed to. I finished my coffee and went inside, already planning my next visit. The cabin would be here, solid and secure, protected by law and by principle. No HOA Karren could take that away from me. Not now, not ever.